Okay, thank you so much for tuning in. We are continuing to talk about the federal rules of evidence. And today we're going to talk about Article 2, which actually only has one rule, and that is Rule 201. So this is judicial notice. So thank you once again to Bar Exam Drills, who is sponsoring my legal education. Thank you so much for this opportunity. Bar Exam Drills is a great app. This app has more than 2,000 questions to help you to practice for the bar exam. It's just a really nice layout. There's great explanations to all of the questions. They are officially licensed questions, and studies have shown this is really a great way to study for the bar exam. Many people spend a lot of time with lectures and things like that. However, it's just jump in there and start answering questions and understand how questions work. The creator of the app really, in many ways, acts as a personal tutor, is always willing to answer questions, and I just really, really recommend the app. It's actually at a much lower cost than many of the other bar exam programs. And it's not giving you bar like exam questions, it's giving you actual questions from the MBE. Also, want to give a shout out to my other sponsor, Marchica Law Firm in Vermont, who is actually my supervising attorney that is helping me to self study the bar exam, self study law so that I can preparation for taking the bar exam. So, without further ado, just want to get started here with judicial notice, Rule 201. And just let's look at what judicial notice of adjudicative facts. All right. Scope. This rule governs judicial notice of an adjudicative fact only, not a legislative fact. So let's just make sure we're pronouncing this word correctly. I would much rather correct myself than have someone correct me in the comments, but I don't mind that either. So let's just look at the meaning of this word. To make an official decision about who is right in a dispute, to settle judicially, right? So
Adjudicate.
it comes from adjudicate. Okay, we know adjudicate, but this is a matter that has been adjudicated or decided judicially. So what is then, okay. Adjudicative facts are those which concern the parties to some dispute and are helpful in determining the proper outcome in the case. All right, so hopefully I'm pronouncing it right. If I'm not, please correct me. And yeah, so let's get back to Rule 201. So B, so it's not a legislative fact. It is a fact that has been judicially decided. So B, kinds of facts that may be judicially noticed. The court may judicially notice a fact that is not subject to reasonable dispute because it is, one, generally known within the trial court's territorial jurisdiction, or two, can be accurately or readily determined from sources whose accuracy cannot reasonably be questioned. C, taking notice. The court may take judicial notice on its own, or two, must take judicial notice if a party requests it and the court is supplied with the necessary information. D, timing. The court may take judicial notice at any stage in the proceeding. E, opportunity to be heard. On timely request, a party is entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice before notifying a party, the party on request is still entitled to be heard. F, instructing the jury. In a civil case, the court must instruct the jury to accept the noticed fact as conclusive. In a criminal case, the court must instruct the jury that it may or may not accept the noticed fact as conclusive. Oh, this is amazing. So this is something that I've been seeing in a lot of the evidence questions that, and I've been a little bit confused, but in a civil case, the court must instruct the jury to accept the notice fact as conclusive, period. But in a criminal case, the court must instruct the jury that it may or may not accept the notice fact as conclusive. So civil, you must accept it. Criminal, you may or may not. Wow, mind blown with that point there. So this is some people view this as a little bit boring, but I reading through these rules, really is helping me to understand the rules based on which the questions from the MBE are going to be asked. And from what I'm understanding, having gone through so far, probably Let's see. I've gone through, oh, at this point, close to 500 questions at this point, close to almost 500 questions. Um, this is really helping me to understand the importance of understanding these rules because these rules are what are going to be tested on the bar exam. So this was a very short one. Article 2 turned into the next video where we will talk about Article 3, which is presumption in civil cases. You know what? We're just going to do it in the same one. These are so short. Let's just go ahead and do it. So Article 301, presumptions in civil cases generally. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. But this rule does not shift the burden of persuasion, which remains on the party who had it originally. So, in a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. So, if if I produce evidence that makes a presumption, right? You are required to produce the evidence to rebut the presumption, right? So, yeah, or not even, it doesn't even say evidence. So the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. Okay. But this does not shift the burden of persuasion, which remains on the party who had it originally. So the person who originally was supposed to persuade still has to persuade. However, when a presumption is made, you have the ability to rebut, but that's on you. You have to produce the evidence that will rebut the presumption that I made. But if I originally had the responsibility to persuade, I still have the same responsibility. All right, so let's go ahead because there's only one more here, and let's look up Rule 302, applying state law to presumption in civil cases. In a civil case, state law governs the effects of a presumption regarding a claim or defense for which state law supplies the decision. So a series of Supreme Court decisions in diversity cases leaves no doubt to the relevance of Erie Railroad Company v. Tompkins. These decisions are City Service Oil v. Dunlap. Okay. They involve burden of proof respectively as to the status as bona fide purchasers, contributory negligence, and non-accidental death suicide of the insured. In each instance, the state rule was held to be applicable. It does not follow, however, that all presumptions in diversity cases are governed by state law. In each case cited, the burden of proof question had to do with a substantive element of the claim or defense. Application of state law is called for only when the presumption operates upon such an element. Accordingly, the rule does not apply state law when the presumption operates upon a lesser aspect of the case, i.e., tactical presumptions. The situation in which state law is applied have been tagged for convenience in the preceding discussion as diversity cases. The designation is not a completely accurate one since Erie applies to any claim or issue having its source in state law, regardless of the basis of federal jurisdiction, and does not apply to the federal claim or issue, even though jurisdiction is based on diversity. Hence, the rule employs as appropriately descriptive the phrase as to which state law supplies the rule of decision. The language of Rule 302 has been amended as part of the restyling of the evidence rule to make them more easily understood and to make the style and terminology consistent throughout the rules. These changes are intended to be stylistic only. There is no intent to change any result in any ruling on evidence admissibility. All right, so once again, Rule 302, in a civil case, state law governs the effect of the presumption regarding a claim or defense for which state law supplies the rule of decision. So even though we're talking about a federal case, a civil case that's in the federal courts, the state law governs the effect of the presumption regarding a claim or defense for which the state law supplies the rule of decision. So the state law supplies the rule of the decision, then the state law governs the effect of presumption regarding a claim or defense for which state law supplies the rule of decision. Let's just look here really quick at Vermont, right? We were going to look at Vermont, their rules of evidence, and just see if there is anything about Am I spelling it right? Presumption. It's probably not in Article 1. Let's see if we can go back here to Vermont Rule of Evidence. Presumptions. Presumptions in civil cases. Let's look at Rule 301. Effect. In several actions and proceedings, except as otherwise provided by law, a presumption imposes on the party against whom it operates the burden of producing evidence sufficient to support a finding that the presumed fact does not exist. But a presumption does not shift to such a party the burden of persuading the trier of fact that the presumed fact does not exist. All right, so this is very similar to the federal rule of evidence. Prima how do we say this? Prima facie evidence, a statute providing that a fact or group of facts is prima facie evidence is another fact another fact establishes a presumption within the meaning of this rule. Submission to the jury and instructions. Number one, if the evidence of the basic fact is that no reasonable juror could find the non-existence of that fact, and if the party against whom the presumption operates has not met the production burden imposed on him by subdivision A of this rule, the court shall direct the jury to find the existence of the presumed fact. So, instructions to the jury, if the person, no reasonable juror could find the non-existence of the fact, and if the party against whom the presumption operates has not met the production burden imposed on him by the subdivision A. So if the person who the presumption is made against does not produce evidence to negate the presumption, then it can be presumed fact. Two, if the evidence of the basic fact is sufficient to support a finding of the existence of that fact, and if the party against whom the presumption operates has not met his production burden, the court shall submit the question of the existence of the basic fact to the jury and shall direct the jury to find the existence of the presumed fact if it finds the existence of the basic fact. If the evidence of the basic fact is sufficient to support a finding of the existence of that fact, and if the party against whom the presumption operates has not met his production burden, the court shall submit the question of the existence of the basic fact to the jury and shall direct the jury to find the existence of the presumed fact if it finds the existence of the basic fact. Three, if the evidence of the basic fact is at least sufficient to support a finding of the existence of that fact, and if the party against whom the presumption operates has met his production burden, the court shall submit the question of the existence of the presumed fact to the jury on the evidence as a whole without reference to the presumption, provided that if the court determines that a reasonable juror on the evidence as a whole could not find the existence of the presumed fact, it shall not submit the question to the jury. All right, let's go to Rule 302. Amended through September 13, 2022. Okay, oh, nope. Preserved. I'm not sure what that means. So let's go to presumption in criminal cases. So 301 is civil, 303 is criminal. A, presumptions in favor of the accused. In criminal cases, the presumption operates in favor of the accused is governed by the provisions of Rule 301. B, presumptions against the accused. Number one, effect. In criminal cases, except as otherwise provided by law, a presumption operating against the accused permits but does not require the trier of fact upon sufficient evidence of the basic fact to find the existence of the presumed fact. But a presumption does not shift the accused, but a presumption does not shift to the accused the burden of producing evidence or of persuading the trier of fact that the presumed fact does not exist. In criminal cases, except as otherwise provided by law, a presumption operating against the accused permits, but does not require the trier of fact upon sufficient evidence of the basic fact to find the existence of the presumed fact. But a presumption does not shift to the accused the burden of producing evidence or of persuading the trier of fact that the presumed fact does not exist. So that's different than in civil procedures. Okay. Prima facie evidence. A statute providing that a group or group a statute providing that a group or group of facts is prima facie evidence of another fact or of guilt establish a presumption within the meaning of this rule. C. Presumptions against the accused, submission to the jury. When a presumption operates against the accused, the court may not direct the jury to find the presumed fact against him. If a presumed fact establishes guilt or is an element of the offense or negatives a defense, the court may submit the question of guilt or of the existence of the presumed fact to the jury, but only if a reasonable juror on the evidence as a whole, including the evidence of the basic fact, could find guilt or the presumed fact beyond a reasonable doubt. If the presumed fact has a lesser effect, the question of its existence may be submitted to the jury, provided the basic fact is supported by substantial evidence or is otherwise established, unless the court determines that a reasonable juror on the evidence as a whole could not find the existence of the presumed fact. D. Presumptions against the accused. Instructions. Whenever the existence of a presumed fact against the accused is submitted to the jury, the court shall instruct the jury that if it finds the existence of the basic fact, it may regard that fact as sufficient evidence of the presumed fact, but is not required to do so. In addition, if the presumed fact establishes guilt or is an element of the offense or negatives a defense, the court shall instruct the jury that its existence on all the evidence must be proved beyond a reasonable doubt. So here is the instructions. Whenever the existence of a presumed fact against the accused is submitted to the jury, the court shall instruct the jury that if it finds the existence of the basic fact, it may regard that fact as sufficient evidence of the presumed fact, but is not required to do so. In addition, if the presumed fact establishes guilt or is an element of the offense or negatives a defense, the court shall instruct the jury that its existence on all the evidence must be proved beyond a reasonable doubt. All righty. So this is the Vermont rules of evidence. Okay. So we came and looked at the Vermont rules of evidence because we apply state law to presumptions in civil cases. So in civil case, a state law governs the effective presumption regarding a claim or defense for which the state law supplies the rule of decision. So I guess my question now is, what happens in a criminal case? And I'm not sure about that, but we can do a little research on that. I do want to look up one other thing before we close here. I just want to look up basic facts, legal definition, and see what that means. Basic fact. From Law Insider, basic fact. Okay. Finding will be used to facilitate resolution at the lowest level. Example 1, basic fact pattern. CSD is a registered owner of issued book, provides of information. Let's look again. Fact. Incident, act, event, or circumstance. A fact is something that has already been done or an action in process. It is an event that has definitely and actually taken place and is distinguishable from a suspicion, innuendo, or supposition. A fact is a truth as opposed to a fiction or a mistake? A question of fact. In litigation is concerned with what actually took place. During a trial, questions of fact are generally left for the jury to determine after each opposing side has presented its case. By contrast, the question of law is ordinarily decided by a judge who must deal with applicable legal rules and principles that affect what is transpired. So, fact, an actual thing or happen, which must be proved at trial by presentation of evidence and which is evaluated by the finder of fact, a jury in a jury trial, a judge if he or she sits without a jury. Facts. Facts can be inferred from other facts. So, what is a basic fact? Okay. I'm not sure what a basic fact is. I have to do some research and share that in our next video because we need to understand what is the difference between a basic fact let's just go back here a little bit. Yeah. Okay, a basic fact versus a presumed fact. We need to understand the difference. So look for that in the next video. Thank you again for Bar Exam Drills and the Marchica Law Firm for helping me to become a lawyer without law school. Looking forward to continuing these videos with you. Please check out Bar Exam Drills app. It is a great way to study for the bar exam coming up again in February. All right. Thank you so much. Bye-bye.